got everybody that RSVP'd, so slim quorum, but a quorum nonetheless.
A slim quorum still counts. Great. Thanks, Justin. Appreciate you tracking that. Let's go ahead and dive in then. And if other folks join, they can introduce themselves as they hop in. Let's call this meeting to order, do some introductions, and then go over the agenda. And I've got one quick announcement to make before we dive in after we look at the agenda. First off, thanks everybody for joining on this bonus extra credit session of the Groundwater Advisory Committee. I'm excited to talk more about these water rights, contested case, and forfeiture rules. Really do appreciate Katie, Laura, and Raquel for joining us to guide us through that conversation. Let's go ahead and introduce ourselves really quickly. I'm Zach Freed, a hydrologist for the Nature Conservancy. I lead the Nature Conservancy's freshwater program. I serve as the GWAC chair for one more meeting, this very last one, and that's part of the announcement I have to make later. And I'm calling in from Bend, Oregon. Let's go into the room, Justin, then we'll go back out to the folks online.
Okay.
Richard Smith, Cooper Mountain Critical Groundwater Area, grouchy old nut farmer.
Eric Schneider, water well driller with Schneider Water Services.
Linda Ray, Administrative Specialist for Technical Services Division, support for GWAC.
Chris Bird, Manager of the Well Construction Section here at the department.
And I'm Justin Iverson, I manage the groundwater section.
Great, and we don't have a huge list of people online, so we'll ask the GWAC committee members to introduce themselves first, then we'll go around with the department staff. So Robin, Stephen, go ahead.
Robin Cook, hydrogeologist with GSI Water Solutions in Portland today.
Stephen Patton with the City of Milton Free Water.
Awesome. Thank you, Robin. Thank you, Stephen. Department staff, where should we start? Maybe Annette, then Raquel?
Good morning. Annette Liba, Technical Services Division Administrator. I am here to listen. Thank you.
Hi, Raquel Ranciere. I'm Deputy Director of Strategy and Administration for the Oregon Water Resources Department. Maybe we should go to Katie next, Zach, if that works. Okay, Katie. Great. And then maybe we'll go Katie, Lisa, Laura, if that works for Zach. Okay, great.
All right. Good morning, everyone. Thank you so much for having us. I'm Katie Ratcliffe. I'm the Water Rights Services Division Administrator here today to talk with you about our rulemaking.
Good morning. I'm Lisa Jaramillo. I manage the Transfer and Conservation section, and I get to talk about rulemaking today too.
Good morning. I'm Laura Hart. I'm a water policy analyst and the rules coordinator for this rulemaking. Good to see and hear everyone this morning.
Good to see you too. Thanks again, everybody, for joining. Justin, we've got a lot to talk about, but actually a relatively short agenda itself. Do you want to take us through the agenda real quick? Then I'll provide my announcement.
Okay, that sounds great. Let's see if I can quickly share that agenda just so everybody can see it on the screen. Okay, so everything today is focused around the groundwater portions of a larger rulemaking that is intended to update. Sorry, that's very small. The rules around processes for water rights transactions, contested cases, and so the way that we've set this up is to, first of all, have a presentation from the rulemaking team that is going to, again, focus on the groundwater aspects of a larger rulemaking effort. Then we wanted to have a public comment period so that anybody that wanted to provide public comment to the committee could do so before deliberation or discussion, and then we'll use the rest of the time for the committee to discuss or ask questions regarding the draft rule changes. And if a feel so moved to provide a statement of advice to the Water Resources Commission. So public comment period is open. I think, well, the presenters will tell us when it closes, but it's relatively soon. So goal is to have GWAC's input during that open public comment period. That's why we have an off-site meeting. And yeah, and I'll leave it there.
Great, thank you, Justin. I noticed that there's not any members of the public that I can tell on the Zoom portion of the call, and I don't see any members of the public in the room. Linda, Justin, do we have any indication of anybody signed up in advance who wants to provide public comment today?
I did not receive any
No, we haven't
invitation,
received any.
Okay, great. Well, we will double check when we get to that agenda item after the presentation. But for the committee's sake, I would say that just wanted to note that we have, as we have the past few meetings, we are rearranging the agenda slightly to, if there is any public comment, to receive that comment before the committee has our discussion so that we can have an informed discussion based upon what we're hearing from members of the public. And that's a relatively recent change, but we've been trying it out over the past several agendas, several meetings. So I wanted to call attention to that, even if it's just a formality today. One last quick thing, just wanted to flag for the committee members that this is not our regular quarterly meeting. This is a bonus extra session of the GWAC that is called for to debate or discuss this rulemaking in particular. Once we get to our first regularly scheduled quarterly meeting of 2026, we will be soliciting nominations for a new chair, new co-chair. So just wanted to plant the seed early if you are interested in serving in that role, or interested in throwing one of your compatriots under the bus by nominating them. Please think about that in advance before we have our next call. Yeah, Justin, anything else to add there?
That all sounds great. Thank you.
Cool. All right, in that case, let's jump into the presentation itself. We've got Katie, Lisa, Laura, and Raquel. And Katie, Lisa, Laura, Raquel, please do feel free to, as you're presenting, if there's anything in particular that you want thoughts, feedback, input, or discussion from this committee on, please feel free to highlight it for us. Don't be shy. We're a small group today, so we can be a little more casual than usual.
Okay, good morning. Again, my name is Raquel Ranciere, and I will be one of your co-presenters today. And we are pleased to be here to present updates to the water right transactions, contested cases, and forfeiture rules. One thing I'll note is that we did discuss initially parsing through what was in these rules that was focused on groundwater versus surface water. As we know, your focus is on groundwater. That proved to be a little challenging, and so we decided to not do that. And because many of the rules apply to both groundwater and surface water, and there are a few exceptions, but as a result, you're getting the whole picture as opposed to just a slice. So we'll just note that for you, even though I know your focus is on groundwater in terms of your recommendations to the commission. So let's go to the next slide. And this PowerPoint is... Laura, is the slide stuck?
Yes.
Great.
Sorry, I was trying to figure out if my volume was still on, but it's okay. I'll figure it out later. So.
Okay, so still stuck? There we go. Okay. All right, so the agenda for today is we'll provide you with a brief rulemaking background, which I think is helpful context for understanding the scope of these rules. And then we will provide you with a high-level overview of the rules. You all received several weeks ago the packet that has all of the rulemaking changes in it. That's the notice of proposed rulemaking. And it's this big. So What that means is you're getting a high level. We're touching on some of the areas that we think are of higher interest. We're not touching on every single change in the rules. So I just want to note that because it's not that we wouldn't love to be here all day, but in the interest of everyone's time, that's why we did try to get that packet to you early in advance of this meeting in case you wanted to look at particular rule sections. We're happy to take questions on any of the rules, but I just want to note for the purposes of the presentation, we're not touching on every single rule change. We'll then go over next steps, and then after that, we'll have time for questions. So let's go to the next slide, hopefully. Oh, it's working. All right, there's the background. Keep going, Laura, please. Thank you. Okay, so we are going to talk a little bit just about the high level, what is this rulemaking? And for those of you that have been interfacing with water right transactions in particular, I think this will resonate with you, is that so OWRD recognizes that our water right transactions in contested cases have significant backlogs and are not being processed timely. And this rulemaking seeks to address that by making sure that rules are clear, efficient, and consistent, and will maximize the limited staff for more timely decisions. So we don't have, we know that it will require more staff to fully knock out all the backlogs. At the same time, we think we need to be doing everything we can to maximize the staff that we do have and make as much progress as possible. So the rules do that by implementing the two major pieces of legislation that passed in 2025 related to water right transactions in contested cases, as well as by aligning rules with other statutes and legislation, implementing other process and policy improvements, and undertaking a number of housekeeping items. So in some cases, there are rules that have, for example, not been updated since the statutes have changed years ago. And since we will be in these divisions, we are taking that opportunity to update those rules. But we are also undertaking the opportunity too, if there are policy or process improvements that we've been meaning to address in these rules, we have done so. That said, there are some areas where we just didn't have enough time to really do enough research to dig into some of the policy issues that people wanted us to dig into. So we're trying to strike that balance with this rulemaking, knowing that it is a lot. So let's go to the next slide. Okay. So I think before we talk about the rules, it's helpful to know, what do we mean, particularly when we say water right transactions? And so for those of you, you all are probably familiar with the water rights process, but just give you some orientation here, just to make sure we're all on the same page. So I think it's helpful to know what we mean when we say water right transactions, forfeiture, and contested cases. And I think I like to think about it in the context of the life cycle of a water right. And so this slide has essentially new water right authorizations. So first, there's the process to apply for a new water right, and that results in a water right permit. And that authorizes a person to develop that water. While it's in the permit stage, one could also apply to change that permit through a permit amendment, or split the permit into two separate permits, or to extend the development timeline through an application for a permit extension. And then once that permit has been developed, one would submit a claim of beneficial use, demonstrating they've developed the water right within the terms and conditions of that right. And then that would result in the issuance of a water right certificate from the Water Resources Department. At this point, I would note, since we're talking about new authorizations, there's a similar, but not exactly the same process for state agency in-stream water rights. And so there's an application process for that. And then there's also an application process for limited licenses. And limited licenses are essentially a temporary authorization to use water. So all of the processes that I just outlined are part of the water right transactions that we're talking about today. Let's go to the next slide. Okay, continuing on the water right life cycle. We talked about you get a water right certificate, right? And with the water right certificate, you can also make changes to that certificate. And specifically, you can put water in stream, or you can apply to transfer, is what we call a change to it, or you could do a conservation project. And when we talk about a change to a certificated water right, we're generally talking about a change in the type of use, place of use, or point of diversion. And it really depends on the water right transaction process as to whether or not, even with permits, whether or not that can, all of those types of changes are allowable. And then Oregon water law also requires that water to be used according to the terms and conditions of the permit once every 5 years. Otherwise, it could be considered forfeit and canceled. And so that essentially would be the end of the life cycle of the water right. So now we've gone through the whole life cycle. All of these different processes are under discussion as part of this rulemaking. So next slide. The other piece that I think is helpful to know with this rulemaking is that a lot of it has to do with processing steps, right? Because a lot of these rules are about the actual processing of these applications. And so now that we've talked about these types of transactions, let's talk briefly about processing steps. And not every transaction is the same, but this rulemaking does start to move many processes, particularly for if they're permanent processes, to have an initial review. And that's where we take an initial look at the application and then share that for public comment, and then the applicant's comment, and then we move that to a proposed final order outlining the department's proposed decision on the application. And so this rulemaking moves a lot of the permanent processes where towards that. And then once the proposed final order is issued, right, we issue that public notice, there's an opportunity for people to protest that application. If no protest is received, the order will now become final automatically. So that's a different processing step than what we've seen before. We didn't have orders becoming final automatically. We had to issue a separate separate final order. And so it's a whole nother step. So with this water right rulemaking, you're going to see that be different on a lot of these processes. If there is a protest, then it will continue on to the contested case process. And for the contested case process, I think it's important for us to note that, so these rules make updates to Division 2, as we'll talk about, and that's our contested case rules. Those rules don't apply to adjudications, by the way. So we're not getting into water rights adjudications, which is a much more complex topic. But these contested case hearings do apply more broadly. So these rules apply more broadly than just the water right transactions rules. So that's important to note as we go through that process. So if a water right transaction is protested, and I should note this also includes forfeiture, right? So if a proposed final order on forfeiture is protested, or some other, enforcement, for example, an administrative hearing is held before an administrative law judge, who then issues a proposed order. And when that happens, there's some variation in the process, but generally there's the opportunity for sorry, I just lost my train of thought there. I did the bad thing of not turning off my cell phone volume and it's beeping at me. So I have fixed that, but I apologize for getting distracted there. So when there are different processes for exceptions, But ultimately, the outcome of that contested case process is a final order. And that's issued by the commission or by the department, depending on the process with that. So this is a good time for me to note to the rest of the staff, make sure your phone's off. All right, let's keep going. Okay, so I already covered this slide, which is, if you want to see the details, please see the official rules notice. But I'll note for this PowerPoint, we've kept, in order to help you all keep on track of what we're covering, we've highlighted in blue the items that we're going to discuss for the most part. So that kind of helps everyone see what are the parts that are not being covered, knowing that not everything will fit on these slides, right? But it gives you an idea. So let's go ahead and move into our Division 2 rules and the proposed rule changes. Before we do that, I do want to note that we do have an errata sheet. We found that we've found 2 issues with the rules in the notice of proposed rulemaking. The good news is that you can still tell what we're trying to do with them. But because the rule summary for the first one on this page is incorrect, but the rule language is correct. The proposed rule language is correct. And then for the second one, it's the opposite, where the rule summary is correct, but the proposed rule language is incorrect. There is an errata sheet that's posted on our website, so you can see the details of that. I don't know if that got sent out to this committee directly, so we will make sure that, Laura, if you can make sure that Justin gets a copy of that, because we outlined it in more detail, if that's helpful. We can share that out with the committee so you have that handy. Okay, so let's go ahead and move to Division 2. Okay, so as I noted, some of this rulemaking is implementing legislation from 2025, and legislation in 2025 allowed OWRD to be able to send and receive documents in electronic format, as well as established a standardized process for protests, requests for party status, and contested cases. And it provides that proposed final orders will become final automatically 33 days after the close of the protest period. So that was that automatic thing that I was talking about, right? Where the proposed final orders won't require issuance of a separate final order, as long as there's no protest. You will see these themes in other rule divisions, right? So this is one of the overarching pieces of this rulemaking. And the statute also requires the department to develop a hearing schedule for hearings to be completed within 180 days. This 180-day time limit influences other parts of the processes, is that timeline requires, for example, discovery to be efficient in order to meet those timelines to get that hearing done in 180 days. It's also important to note that legislative changes did not apply to contested cases related to enforcements, adjudication, or hydroelectric. And the legislation was more specifically focused on the various water rate processes that I outlined in forfeiture. However, there are some changes that the department has authority to make even without the 2025 legislation. And in the interest of standardization, you'll see changes in the rules that apply only to the types of transactions covered by House Bill 3544. But then other parts where we do have authority, you will see broader changes that apply to all OWRD contested cases, except of course adjudications, because these rules don't apply to adjudications. So let's go to the next slide. Okay, continuing on with Division 2. The rules also include a number of actions that are intended to make the contested case process more efficient, timely, and cost-effective. This includes allowing the department to determine consolidation or bifurcation of hearings prior to referral, as well as placing limits on discovery, including not allowing requests for admission as a means of discovery, limiting interrogatories to 10, and limiting requests for production to 30 hours before requiring a public records request. With the significant contested case backlog, the goal here is to provide a process that allows for due process, but is also efficient and cost-effective for all parties, and allows us to make timely decisions in these contested cases, given the extent of the backlog and how long that backlog has been pending. So let's go ahead and go to the next slide, and I'm going to hand it off to Katie Ratcliffe to continue on.
Thank you, Raquel. I'll walk us through the next several divisions before handing things over to Lisa Jaramillo. So let's start with Division 305. That's a new rule division that would establish standardized criteria for maps submitted to the department for water right transactions. The intent is to reduce confusion and increase efficiencies by standardizing map requirements in one place. Please note that additional specific map criteria may apply as specified in application-specific rule divisions. Next slide, please. Division 14 rule amendments would create clear linkages between Division 14 and our Division 217 rules, which contain requirements for pump testing of non-exempt groundwater wells. Under the Division 217 rules, the department cannot process a claim of beneficial use on a groundwater permit until the pump test requirement has been satisfied. However, there's currently no requirement to submit that information with the claim of beneficial use, and this leads to inefficiencies and confusion for claimants. The rule amendment would require pump tests or pump test exemption requests be submitted with the claims of beneficial use for groundwater permits. Next slide, please. Division 300 houses our definitions for many water right transaction processes. The rule updates include creating alignment with statute and across other rule divisions and other housekeeping changes. Next slide, please. Division 310 contains the rules for new water right applications undergoing the standard review process. This slide shows that in addition to the two major pieces of legislation impacting this rulemaking, we have a third that impacts Division 310. Senate Bill 1154 streamlines the public interest review of groundwater applications in a groundwater quality area that would consolidate drinking water wells under a public water system. The intent is to help address water quality issues faced by exempt wells in those areas. Next slide, please. The rule updates would also require notice to a landowner if someone other than a landowner applies for a water right on that landowner's property. This is a due process requirement. If a person is signing on behalf of an entity, such as a corporation, the rules would require evidence that they have authority to sign on behalf of that entity. The draft rules remove informational requirements that we believe are unnecessary because we have other efficient means of obtaining that information. The existing new water right application process under 310 allows for administrative holds, which, if granted, prevent the department from issuing a proposed final order during the duration of the hold. The rule changes would define what a reasonable and necessary hold is. We also propose to update this division to improve consistency with our Division 5 rules, which describe how WRD determines that a requested water right transaction is compatible with land use requirements. The revisions remove language stating that the department can presume compatibility with land use requirements unless an affected local government informs us otherwise. The revisions also remove the option for new water right applications to be found complete by only including a receipt from a local government official, as this does not provide any information about land use compatibility. Next slide, please. Division 315 contains our rules for extensions. So, as Raquel referred to, water right permits set a deadline for completing construction of water infrastructure such as pipelines and putting the water to beneficial use. An extension allows somebody who holds a water right permit more time to finalize these steps. House Bill 3342 set limitations on the number and length of extensions of time. These are non-discretionary and must be implemented through this rulemaking. Because of these new limitations on the length of extensions, the proposed rules would remove checkpoint conditions. These conditions currently apply to extensions exceeding 5 years and require the permit holder to update the department on how development under their water right is progressing. The rules add information about how the proposed final order on the extension application may initiate permit cancellation proceedings if an extension is denied and requirements for cancellation are met. Next slide, please. Division 340 contains rules covering a variety of topics, including rules governing the expedited secondary process for use of stored water. The changes would provide greater clarity on how the department determines that a public interest or that a public comment has raised or identified a public interest issue that merits moving the application out of the expedited process and into the standard review process. The intent is to provide greater clarity following recent litigation. Division 77 contains our rules for in-stream water right applications. In addition to implementing 2025 legislation, these rules implement 2023 legislation. This legislation allows a water right holder to split their use of water within the same year, to use water under the water right for part of the year, and lease water in-stream for another part of the year. Thanks, Laura. The division, or Justin, whoever's keeping up with me, thank you. The Division 77 rules clarify that any rule or order withdrawing a natural lake or stream from further allocation does not withdraw it for in-stream public uses unless the rule or order specifically states that it is prohibiting in-stream public uses, or the water body was withdrawn for the exclusive use of a municipality. The rules would remove the process for canceling an in-stream water right based on non-use. These rules will be removed due to conflicts with rule and statute and because it is unclear how WRD would ever determine that an in-stream water right has been forfeited. To align with existing statutes, the rules remove estimated average natural flow as a limitation on the amount of water that can be protected in-stream for transfers, leases, and allocation of conserved water projects. Our proposed rules for minimum perennial stream flow conversions would add language from statute describing how minimum perennial stream flows established before June 25th, 1988 shall be converted to in-stream water rights. The rules would align the steps to complete those conversions with the process described in statute, which includes issuance of a proposed final order. Handing it over to Lisa Jaramillo now.
All right, thank you, Katie. So continuing on with Division 77, the proposed rules provide clarity that the department may only issue in-stream water rights, in-stream leases, in-stream transfers, and in-stream water rights resulting from an allocation of conserved water project for stream reaches that are located within Oregon's borders. Changes were also made to clarify that storage rights may be permanently transferred in-stream provided certain criteria are met. And then there were further changes made to align certain definitions with other rule divisions, clean up obsolete definitions, and add or update existing definitions for clarity. Next slide, please. To process streamlining for both the applicant and the department for in-stream leases where the lessor is a district, the proposed rules allow written authorization from each district user involved in the lease to be maintained at the district and available upon request, instead of the district having to provide this information with the lease application. The proposed rules also add a streamlined process to renew an in-stream lease if it meets the criteria, such as the renewal application is submitted within 5 years from the date of expiration set in the last final order approving the lease, and it does not propose any changes to the in-stream use or quantity of water protected. Related to precedents of future uses, our existing rules provide a process for applicants for certain types of new water rights to request the new water right take priority over an existing in-stream water right. The proposed rules were modified to align with statute and to follow the water right application processing steps. Next slide, please. All right, so now we've got Division 325, which is commonly referred to as the split a permit process. Many of the changes in this rule division are to implement the 2025 legislation, clarify the existing rules, and to create consistency across rule divisions by implementing an initial review phase of processing, which includes preparation of draft replacement permits so that the applicant can review them before they become final. The rules make several other changes to align to statute or other rules. The biggest change being that the department can approve an application for splitting a permit even if the completion date is expired. This is pursuant to a review of the text of the statute. Next slide, please. Allocation of conserved water is a voluntary program that allows water that is conserved through implementation of permanent physical changes to infrastructure to be used on other lands. The program requires at least 25% of the conserved water to be dedicated to the state, usually for in-stream purposes. These rule changes are mostly to align with legislation and to create consistency in processes across rule divisions, particularly for processing steps. The changes also provide clarity around existing processes, such as that any change in point of diversion can only be made from the same source of water, and that the department does require water use measurement and reporting. Finally, many of the changes clarify or reorganize the rules to reflect the various steps associated with a conserved water project. First, if all the requirements are met, the conserved water project is approved. The next phase of the process is for completion of the changes, followed by a testing phase to confirm the amount of water conserved, and then finalization of the project. Next slide, please. Now we'll look at Division 380 rules for water right transfers. Most of these items have been discussed in the context of other rules, so we'll just keep moving along here. Next slide, please. The proposed rules include several changes. The Oregon Water Resources Department reviews both injury and enlargement when evaluating a change, and the proposed rules make that clear. The changes establish a more efficient process for renewing a temporary transfer, and the changes establish new rules for permit amendments. The department has been operating without rules ever since this program was established, and this will codify existing practices and align, to the extent possible, the process with other transfer rules for consistency purposes. Next slide, please. Additional rule amendments for permanent transfers clarify that if the change under a point of diversion or point of appropriation transfer is not made in the time specified, the transfer holder can request to revert the point of diversion or point of appropriation back to its original location prior to the transfer. The proposed rules also clarify that for place of use changes involving water rights with an authorized place of use tied to specific acreage, such as an irrigation right, the water right acreage identified for the place of use transfer must actually move to a new location. In other words, a place of use transfer should not include any acreage under the water right that is going to stay in the same place. Next slide, please. These rules make several changes to the program that allows for changes in the point of diversion to reflect historical use, where the point of diversion has been in use for 10 or more years. The changes make the review process clearer, including the process for evaluating injury and enlargement. The statute requires the applicant to notify other potentially affected water right holders, and the rules clarify that process, including that the applicant must provide proof that the notification occurred. In addition to other changes, the rules make it clear that this process cannot be used for groundwater rights or changing the location of a dam. While it appears to the department that groundwater was not contemplated by the statute, OWRD is conducting a deeper review of the legislative history to confirm. The changes for housekeeping summarize some of the additional changes captured in this rulemaking. Many of these changes are either to align with existing statute, have already been discussed, or codify current agency practice. Next slide, please. Groundwater registrations are claims for groundwater rights that predate 1955 and have not been adjudicated. The process for making changes to a groundwater registration are authorized by statute but specified in rule. Most of the changes try to align with the Division 380 rules so that there's consistency. As such, most of the items have already been discussed for other rule divisions. One area to highlight, however, is that House Bill 2803 increased the maximum fee that could be charged for groundwater registration modifications. The current fee was set at what was formerly the maximum fee for all applications, except for only a change in place of use, where the fee was set at 70% of the maximum. The rule change points to statute instead of writing the actual fee numbers in rule as was done in the past, so that it will simply adjust when the statute is adjusted. Currently, this would mean a fee of $1,900, which is 70% of the max fee for a place of use change only, and a fee of $2,730 for all other changes or combination of changes. And I will hand it back over to Raquel.
Thank you. Thank you, Lisa. Okay, so now we're moving into Division 17, and this is the cancellation of perfected water rights, otherwise known as forfeiture rules. And these rule changes specify that the director, instead of the commission, will consider exceptions to an administrative law judge's final order. The rule specifies that when forfeiture is asserted as part of a transfer proceeding protest, OWRD will issue a notice of cancellation proceeding to provide the notice required by the forfeiture statutes, but not require the water right holder to submit a protest, instead addressing the matter of forfeiture in the transfer proceeding. The rule also modifies the process by which a water master submits an affidavit for 5 years in a row, stating that to the best of their knowledge, there is no physical way the water may be applied to a beneficial use. This is under ORS 540-661, by the way, by providing a broader scope of information than just a field inspection. Although it does provide that a field inspection can be part of that affidavit's evidence. For a different cancellation process, the changes also remove the requirement that OWRD staff submit an affidavit when the department initiates cancellation. So this is under a different process. And the department, the reason for this is the department issues a proposed final order, which must meet statute and rule requirements, and does not see the purpose of submitting an affidavit to itself. So the rules also make updates that clarify what information the department can use. So with that, let's go to the next slide. Okay. So this slide here shows the rulemaking timeline. As you know, we always have a RAC generally. So we did have all those RAC meetings, and we're currently in the public comment process. So we already had our public hearings. And the last day of public comment is February 6th. And that is why you all are having a special meeting, right? So we can also get your advice on the matter before that comment period closes. The agency will be reviewing those comments in February and March, and the commission is expected to make a decision on the rules on March 19th. And then the rules will go into effect. I'll note that it's important to pay attention, though, to the applicability sections, because there are some rules that apply before the rules are adopted, and a lot of that is in part because of the legislation that they pertain to went into effect earlier. So important to look at the applicability sections to note when they are truly effective. So let's go to the next slide here. I think we are at that point where we can close the PowerPoint and see what questions the group has.
Fantastic. Thank you, Raquel. Thanks, Lisa, Katie, Laura. Appreciate your hard work on this. And it's clear that a lot of effort went into these changes, which, if you count it by the number of divisions affected, seem very sweeping, but if you count it by the topics considered, it's very targeted. So thanks for your efforts there. I quickly do want to look at the time. We're a little bit past when our public comment period allegedly was going to happen, should there be any public comment. So before we take any questions, I wanted to just check in. Is there anybody online or in the room? I'm looking right now. Anybody online or in the room that wants to provide public comment? I see that I don't think there's anybody online. Justin, did anybody barge through the door eager to provide comment?
Oh, nobody else has joined us in the room.
Okay, great. Then let's skip that entirely. Public comment period is the public comment period is ongoing through February 6th, but the public comment portion of our agenda right now today, we're gonna skip on over. And of course, if folks join later, we can consider that. But as usual, I want to open it up for clarifying questions from the committee members first. Once we've satisfied our curiosity, once we have a good understanding of the material, then we can discuss potential recommendations to the Water Resources Commission. But I'll shut up. What kind of questions do you have? That was a lot of material. What questions, committee members, do you have for department staff? Richard, go ahead.
On 380 and 382, it appears to me, reading over it and listening to this, that if there's a transfer being made, that the only notification is going to be on the WRD's website weekly. And I'm wondering how neighbors are supposed to know, or do they basically have to check in 52 times during the year to see if a neighbor is going to do a transfer?
I can take that, Raquel. Yeah, thank you, Richard. So with currently our process is when we get a new application in the door, we publish notice of that application being received and request comments on it. And then we prepare the initial review, basically. That's between us and the applicant. And then we would go out with a proposed final order, which starts the protest period. And then anyone who provided written comments on the application, we would copy when we send out that proposed final order. And what the proposed rules are going to do is they just kind of reorganize that a little bit. So when we get a new application in, provided the rules are adopted, we would prepare the initial review, and provided the applicant affirmatively tells us to please continue processing and provides anything we identified that is lacking, then at that point, we publish notice of the initial review on our website, again, taking comments, and then we consider those comments, go to proposed final order. So so currently we're doing the same thing that we have been doing. We're just reorganizing the order and how it's done.
Lisa, can I add to that? And so
Sure.
you can see if I'm remembering this correctly. So
Sure.
currently, there are the mechanisms for the neighbors to know would be, one, we do post it on our website. We issue, if you sign up for our weekly public notice, which is a email newsletter subscription, you would receive that weekly public notice. There is also the option to request physical mailing of the weekly public notice. And then the other potential option would be that today, that's going to be different, is that currently there are certain transfer applications where we are required to provide notice in the newspaper. As the amount of newspapers have declined, that's become more and more difficult. So the 2025 legislation removed that requirement. And now the requirement is if there are more than 5 landowners or five people, maybe is a better way to say it, that are water right holders that are impacted, that we would then need to publish it in the newspaper. So in terms of our transfers and groundwater registrations processes, we don't today have a personal notification to the individuals that are neighbors. So that is already today. So the main distinction is when in the process will the notification occur in our weekly public notice, and then the fact that the newspaper notice has changed. So those are the two pieces there. I will note that the 382, so the groundwater registrations, those are not prescribed by law, but they're intended to be consistent with the 380 transfers processes. So that's why those processes are mirroring each other. Lisa, what did I miss and what did I get wrong?
No, I think you've got it. And
Okay.
then Katie added in the chat the proposed or the requirement or the trigger for a newspaper notice that came out of the legislation. So it's
can you read that for the group, because we should be making sure it's one on the record, and two, there's folks in the room that can't see the chat.
Right. So notice of the proposed final order, we have to notice it by publication in a newspaper having a general circulation in the area in which the water uses subject to transfer are located for a period of at least 1 week or once each week for 2 consecutive weeks if the department determines that more than 5 water rights would be injured as a result of the change proposed in the transfer application. So
That's the new requirement going
that's
forward.
the new requirement, yeah.
And then Lisa, can you remind me one other thing that, since we're talking about notice, I don't remember if it was in 380 and 382. I think I do remember it being in other rule divisions, but not necessarily those two, was the requirement for the county off, well, it wasn't a requirement. It was a ask for counties or the water master to post notices in their office, the local office. And for some reason, I think that was actually in Division 77. I don't remember if that was in 380 or 382, but that would be the other, that's being removed. And
yeah, I think your memory is correct that it was 77 and that was not part of Division 380 or 382.
No. So hopefully that answers the question for folks.
Richard, does that make sense? Any follow-ups?
Well, I have suggestion later on when we're into that phase.
Okay, great. I'll put that in the notes, my notes for a parking lot.
Could I add one thing that might help there too? Just if for some reason a water right transfer is proposing a change and the applicant doesn't own all of the land that's involved, they have to provide us with a report of ownership that shows who owns the land. And if we see somebody other than the applicant on there, then we have to get either consent from the landowner of record to go ahead with the transfer, or that portion has to be removed, because that's one thing we don't want to do, is transfer somebody's water right without them knowing about it.
That makes sense. Thank you for the clarification. Other questions from the committee members? Eric, Robin, Stephen?
No questions.
You understand this stuff a lot better than I do then, but thanks for confirming. Robin, Stephen, give you guys a couple of minutes. Okay, great. See some head shakes. Take that as positive feedback for the clarity of the presentation and appreciation for the presentation y'all gave to prep us for this conversation. Let's shift over into thinking about what feedback this committee can provide, both on the rules and then eventually making a decision about whether this committee is going to provide a recommendation to the Water Resources Commission about this rulemaking. But Richard, you said you had a suggestion on public notice topic, so go ahead.
Yes, I do. I've been in the position of having transfers that were being transferred within 100 yards of my property with no notification. I would propose that the end user of the transfer be required to mail notification to all landowners within at least a mile, if not more, of the proposed point of appropriation. This is with groundwater, not with surface water. Because, as you say, the newspaper availability is really diminished. And I think it's ridiculous to require or to expect the general public to log in every week to the website for the Water Resource Department to check and see if any of their neighbors are proposing to do a transfer. I think that's ridiculous. And speaking as just a domestic water user, how the hell are we to know that we could sign up for a weekly notice from the Water Resource Department? It's I think we owe the general public, in particular, the domestic water users, the knowledge that a irrigation well is proposed close to their property. It not only happened to me once, it happened to me twice. And I'm fairly well tuned into what was going on, and yet I had no knowledge of it until it was too late to make a public comment. So just a suggestion, but I feel we owe that to the domestic water users.
Thank you. I appreciate the comment.
Thank you, Richard.
And I don't think it would be unreasonable to expect the person transferring the water to bear the responsibility of doing that, not asking the Water Resource Department to do it.
But wouldn't there be an issue with knowing who to contact if I was in that position looking at, okay, a mile radius seems a lot of area, could be impacting a lot of people. Instead of adjacent people, I might know my neighbors, but my neighbor's neighbor's neighbor, it just seems like who's going to be impacted is more important.
Well, mostly, in my perspective, where irrigation on a large scale is being done, the houses aren't that close together. We're not talking about that many different tax lots.
True.
If you're in a urban area, sure, you're talking about 100 houses, but like in my area, and mine is fairly developed, you'd only be talking about no more than 20 parcels. Most neighbors know each other. And I don't think it's an unreasonable request to put on the irrigator.
Do the certified water rights examiners have to go ahead and do any, process where they're looking at the area and what's being impacted by these changes, or is that all department done?
I believe that's all department done.
That's correct, Justin.
So the department doesn't, if they look at who's going to be impacted, they don't automatically send out any notices to water rights people that such and such is looking at a transfer that's going to impact your water right.
Yeah, that's correct. So
they have the information, they know the people, they have the addresses because it's part of their water rights, but they may not have all the domestic users because not all domestic wells have logs.
Are registered, yeah.
So it seems like the department has the knowledge versus maybe the homeowner or the irrigator does not.
True.
So seems like an electronic communication to them saying a water right our water right transfer has been requested in your area. Please see the department. Just something generic would be very easy to do.
The issue would come with the electronic communication because, well, we've got water rights and exempt use well of the various precision. We have very few electronic.
So a mailing would have to go out instead.
Yeah.
A generic form letter saying postcard.
Yeah.
Would satisfy that without having to put the onus on people who don't have all the information versus the people who do have the information, would be more reasonable, I think.
Or another option might be to use a similar situation as to land use notices where a sign of a given dimension is posted in front of the property and have a community meeting.
Yeah.
Okay.
Richard, do you think a mailer or generic postcard, or if possible, electronic communication would satisfy your concern?
Either way would satisfy my concern. My question is how many of the electronic addresses are readily available, whereas having been a realtor, I know it's relatively easy to come up with the snail mail addresses for a given area, but difficult to come up with the electronic addresses.
And just follow up on that. I'm just thinking about the change to have the notice in the newspaper for greater than 5 water rights being injured, and I would assume that you would have the contact information for the water right holders there. And I'm also trying to think of a time when a transfer would be approved where there was that much injury. So what would the notice be? That this is out there, but it's going to be denied, or what's the point of notifying the transfer is going to be not accepted, I guess.
Zach, I'm kind of waiting for you to call on us if you want us to ask questions, but
Oh my gosh,
but
thank
I'm
you.
not
Do not wait on me. No, Raquel, over
I'm
to
not
you.
sure that that maybe I think you were waiting for us to just respond. So sorry for the little stare off there. So I think so one, that notice is required by statute, so that there's not really flexibility on there, and presumably it's just to ensure folks are aware. I can't remember, maybe I should look back at the chat if that was at the initial review or PFO stage. I'm suspect is it PFO. So in that case, it would be, in the unlikely scenario, I think you have a point there, is like if it's going to result in injury, then probably the PFO saying denial, right? So it would be in a very unlikely instance, I think, that people would well, it could also be that maybe the applicant protests it, right? And the folks just want to request party status so they can be in the loop, for example. So that I suppose there could be situations where that could come up, where that is of interest. I think on the piece about electronic emails, it is always a struggle to ensure that we have the most up-to-date information for water rights. Water rights change hands frequently. So it is a workload that the water masters, for example, when they're doing their regulation, they're always having to pull information for that. And so it would just be a workload where we would have to go pull that information likely from county records, I believe, Lisa, because I don't think we would have confidence in whatever information we had last on a water right. Some of those could be years before, ago, that we received updated contact information from someone directly. So on the electronic side, it would, we wouldn't be able to particularly ensure that for exempt use wells. So short of an email list where people can sign up and monitor for themselves, we wouldn't have a direct route to be able to pull people's emails from our records. That would ensure everybody gets notified. Lisa, Katie, do you have anything to add? Just, I'm not the expert. I'm the so I want to always make sure I'm not misspeaking here. I see Justin's nodding, so Lisa's nodding. So okay, I just always want folks to feel free to chime in if I get it wrong.
The only other piece would be if we do identify more than 5 water rights that are injured, assuming they are not in-stream water rights that are injured, just individual water rights. The statutes do allow a process for the applicant to obtain consent from those other water right holders to basically allow the injury. So it's a consent to injury process, but that's something the applicant would have to pursue. And that that process occurs even if it's just one, but with more than 5 water rights injured, that's what triggers the newspaper notice. So I guess I just wanted to mention the point that if another water right is injured, the applicant can reach out to that other water right holder to request that they consent to the injury. But that's between the applicant and the other party.
And Lisa, so the legislature removed the newspaper notice in part because they were trying to have the transfers process be more efficient given the amount of time it's been taking to process transfers. And that, if I recall, that newspaper notice could add anywhere from a couple weeks to a month, month and a half to the process, depending on how everything went, if I'm recalling correctly.
Yeah,
and
it's probably at least 3 weeks. It adds at least 3 weeks to the process, if not month and a half or more.
So would pulling the information from tax lot records, can your staff do that pretty efficiently? Or what is usually involved? I think that's what they were trying to understand here.
Well, I mean, depending on it depends on how big of a radius we're talking. It could be time consuming if we're talking a more urbanized area where there's lots of tax lots.
And we don't have to land that plane right now. Appreciate your consideration of that comment. Robin, I see you have your hand up. Go ahead.
Yeah, I just wanted to check on this. It's my understanding that the department also considers exempt uses when they're looking at injury during a transfer application. But is the greater than 5 water rights injury like a paper water right, or would it also include exempt uses?
Lisa and Justin, that's beyond my very short level of knowledge depth. So I will look to you two.
Yeah, Justin, I guess maybe I'd kick it to you first to explain what you guys look at when you're doing the injury review for a point of appropriation change. What all you're looking at there.
Yeah, so we, from a technical review point, we may identify 5 or more exempt users in the vicinity that could be injured. I'm not familiar enough with the rule language to answer your question, Robin, about does that have to be 5 injured permit holders or 5 other injured water right holders? An exempt use, I believe, is considered.
Justin, I guess I would reframe the question is, when you're looking at injury, are you taking into account exempt uses regardless of the amount of exempt uses?
Yes.
Yeah. So, and that's because exempt uses are given the same, essentially, under the statute is water rights. So they're part of that groundwater review process. Lisa, anything to add from there?
I don't think so. We're with the point of appropriation changes, we're relying pretty heavily on the groundwater section to look at those other wells that might be impacted. So if it's identified in there, we're going to follow up on it.
Good question, Robin. Yes, Richard, go ahead.
I know with Washington County, that's the only one I'm really familiar with. I can pull up the tax map just as an individual, not as anything else. And electronically hone in on a given area. It'll show all the property owners, their addresses. Let's say a mile radius in the area I live, which consists of farms from 20 acres to 250 acres, 300 acres. And the mile radius would be less than 20 people. I could have the addresses and type them out in less than half an hour and have them ready for the mail. So I don't feel, in my particular case, now there's going to be a lot of different scenarios. I agree with that. I don't think that would be an unreasonable burden on the person requesting the transfer.
Not all counties provide that information, but
that I'm not aware of what the other counties do. I'm just aware of the Washington County.
I'm just letting you know.
Right.
When I go to do tax lot investigations, not all counties provide the same level of information as Washington does.
Oh, and it's a thorny problem. I understand that, but I've been in the situation where my well was pumped dry by an irrigator that received a permit. Everything without my knowledge at all. The well is within 300 yards of my property. I was not happy.
It seems like this discussion is not about the changes to the rule, but more of, something that should have been added to the rule of during the process, the department has to notify the people who are going to be injured if it's going to be going through. But really the rules changes are about the change in the statutes and removing of some of the things like the newspaper. But there's definitely some room for improvement, it seems.
Agreed. Oh, I'll let it drop at that.
It's good feedback. Thank you, Richard. Thanks for the context, Eric. Stephen, go ahead.
Yeah, I guess my comment is kind of changing topics, and a lot of the rule changes will make forfeiture cancellation potentially easier and accessible through more water right processes. Is there a concern or a way to manage for potential additional use to prevent loss of that? I'm wondering, like, if you're allowing for forfeiture during the transfer, are people going to start using water more because they're going to be going through some of these administrative processes, and it could be the use it or lose it type scenario from a broader groundwater strategy and management?
I'm not sure I'm fully tracking the question, because I don't perceive it as making forfeiture easier. So let me see if we can get some grounding here, and maybe I can sort through what the particular concern is. On the piece, there's one piece in the rules. Well, I should say there's two pieces. One's in Division 380, one's in Division 17, the forfeiture rules, and they're trying to tie back to each other. And essentially, the issue is that today, without these rules, you can, so part of a transfer proceeding, in order to be able to transfer a water right, it must be valid, right? And so through the process, you would submit evidence of use that the water right has in fact been used or is not subject to forfeiture. Someone can come in during the transfer proceeding and protest, let's say, approval of a transfer and say, no, that you can't approve that transfer because that water right has been forfeited. They have not used it, right? And so then that puts us in this weird space that that I think at some point in time we'll want to probably pursue legislation to make it clear of how these two intersect, because those are all in 540-520, ORS 540-520, and then the forfeiture proceedings are in 540. It's in the 600s, so like 621 and 6 on, right? So, but the result is, so we're required to provide notice under the forfeiture statutes that has specific information in it. It says, hey, we're starting a cancellation proceeding, and your water right will be canceled, right? Well, if it's going on in this transfer process, we don't provide that notice over here, then it creates this like conundrum. So the instance where this has happened recently, I think what occurred, and Lisa and Katie, shake your heads if I'm misremembering, is that the transfer proceeding got put on hold. And I think we then started the process through 540, 600 something. And to initiate the cancellation proceedings because we can't transfer a water right that's not valid. So then it had to go through that whole contested case process, right? And then the commission's in the middle of making a decision on that. But then after that's done, then we're going to have to go back to the transfer process, right? Well, the transfer process, let's say that's not the only issue in the transfer, right, that's been raised, then that's going to have to go through a contested case, as opposed to just having one contested case and saying, okay, these are the 5 issues that were raised in the protest. One of those was forfeiture. The other ones are all these other things. Let's do one proceeding, right? So this is trying to make it so we have one consolidated proceeding instead of being like, let's go do one thing, then let's go do, because the statutes aren't clear about how those then enmesh together. So that's what we're trying to do by this. Did we hit the nail? I don't, you all will tell us, the public will tell us, right? But that's what's trying to be achieved on that. There are provisions in Division 17 that are essentially conforming to the law, or well, to the statute, in that the statute provides a broader body of, so for example, on the water master affidavits that are 5 years, the rule currently says site visit. Well, the body of evidence might not just be a site visit. It might be, you know, a full body of evidence of all these different things, right? And so that one, the statute talks about it in the context of that, what is it? To the best of the water master's knowledge, I should have kept it in front of me. Let's see, because I actually read you all the statute. So it's the best of the water master's knowledge, there's no physical way the water may be applied to a beneficial use. And so this one's acknowledging there's broader evidence that could be used in that. By the way, the water right holder gets one of those affidavits sent to them every year for 5 years. So they can go and say in that 5-year period, nope, you got it wrong, right? And if they don't, then that results in the initiation of, or can result in the initiation of a cancellation proceeding. In all those instances, though, there's still a right to a hearing, right? So that's some examples. If I did not hit on the particular issue that you were concerned about, please let me know. There is a lot in these rules, but I think that was the point, the part you were pointing to.
Yeah, that was part of it. And also, I guess just this idea of like the reduction of friction to getting to a forfeiture or cancellation may incentivize people to utilize that water right more, because they see that there's potentially an easier pathway to that cancellation.
Yeah, I don't know. I don't know how to handle, I guess, to answer that one, because I mean, I guess it's in the eye of the beholder whether there's less friction, right? From our standpoint, we have to meet a preponderance of the evidence that that water right has been forfeited. That can be challenging. And that standard has not changed. That's the standard that's been there all along. And we have to have a hearing if a person requests that, right? And the other piece of that, though, to your point about, well, people will use their water right more. Well, it still has to be beneficial use without waste, right? And by the way, you're not required to use, if you are irrigating the full amount, all the acres on your water right, you don't have to use the full rate and duty every year, right? So long as you have a system that has the capacity to handle that. And so these rules are actually adding what has already been in the statute. These statutes have changed a lot. There's a lot of interest in forfeiture, and rightly so, right? It's important. And if you look at the statutes over time, there's all these little provisions that have been added. Those provisions have not been in the rules. So for example, before we even initiate cancellation, if you look at the statute, there's these two pieces that are, we're calling them exemptions, right? Because they're not under the rebuttals of forfeiture. They're actually part of the, like, it's not forfeiture if, right? So you can't even say that it's occurred if there's these drought provisions in there. And then it's under 540, 610, 3 and 4. There's where I'll remember the ORS for you all. But those two provisions in there, there's these exemptions. The other one's that ready, willing, and able if they have a system that is capable of handling, right? And that provisions, both of those we've tied into the definition of forfeiture. So it's actually, you don't meet that definition if those two scenarios occur. So in some cases, you know, whether it's easier or harder, that's, from our standpoint, it's not the objective. That some of the changes make it so, you know, we can do our jobs on that front and make sure the full body of evidence is being considered from our standpoint, and integrating a lot of the provisions of the statute. What people do with that is always, you know, the challenge there, because I think there's still a lot of concern out there that you have to use the entire water right? When it's really, that's not the case. And that is one of those things where I think getting the whole body of professionals to be able to say the same thing, right? And be able to encourage people to know what the law is so they can fully protect their water right, and also make sure that they're only really using the water they need. I think those are the things in the future that we need to continue to work through.
Thank you.
Yeah, thanks, Raquel. Bonus extra credit points for you for remembering not just the statute, but also the sections within the statute. Nicely done.
That's the most common one.
I am a little curious about one very specific proposed change in Division 17. I think maybe Katie presented on this earlier. I'm just curious, shifting the burden of any exemptions to the administrative law judge's proposed order and issuing a final order, shifting that authority from the commission to the director. What was the rationale behind that? Is that simply to avoid waiting for the next commission meeting, or what is the distinction that is being solved for there?
I think that one is a lot of processes have been moved towards the director versus the commission. You know, the history is a long time ago, a lot of the decisions were made by the commission. And then the statutes, when they were all changed over, they kind of just placed commission everywhere in our statutes. And then the authority of the director in a lot of the cases was then delegated through the rules or through a delegation order. So this one is one that would make it so that the director, you know, through our processes could do that. The commission has to get up to speed very quickly on a very detailed topic and record, right? And so I think that's the rationale behind that. And it may very well be that the commission or folks say, no, we really think that for this particular one, it does need to go to the commission. So I don't know that I'm making the strongest pitch here. I think it was just, moving towards the direction of as much being able to be handled by the department as possible. Just knowing that it's a lot to get the commission up to speed very quickly on very detailed issues.
Sure, that makes good sense. Thank you. I have a way bigger picture question that's going to be unanswerable, but I'm curious to get your hot take anyway. The goal of this whole rulemaking process amongst all these divisions is to increase efficiency for water right transactions. Do you have a sense of what the current average time of water right transactions is across all these different processes? And also, this is the unanswerable part, like, what's your best guess about the efficiencies gained through these proposed rules? Are we talking, is it going to be 10% faster? Is it going to be 80% faster? So I'm curious. I know it's going to be tough to answer that second part, but I'm curious about your take.
Yeah, Zach, on the second part, I'm glad that you've acknowledged that it's an unanswerable question, because it is. But I will tell you a little bit about just our approach on this front, which is that, yes, this is intended to maximize our limited resources. And the way I think we've thought about it is that because in some cases it's about rule clarity, right? And so it may not on its face look like it is, let's say it's adding a requirement, right, for the purposes of clarity, right? At the same time, because it's clear, we probably will receive fewer questions on that because everybody knows what they're supposed to do, right? And our caseworkers spend a lot of time answering questions, and our managers spend a lot of time digging into things that are ambiguous, right? And then having to make a decision. So I think that is just a piece that I'd highlight in this rulemaking that is unable to be calculated, right? In terms of the full rulemaking scope, it is really the approach of every minute counts. So in some cases, yes, some of these changes may save us 10 minutes, right? But we're looking at it from the cumulative impact of being able to have those even incremental gains. Means that even if this only, makes it so that we can process 10 applications faster, right? That will help per year. That will help us whittle down that backlog in the right direction. I'm not saying that's what it is. We have not done, we've been asked, and I don't think and Katie and Lisa, you can tell me, I know it's come up every now and then of like, can we estimate how much time various things would save? And I think, the newspaper notice was an example where we were able to calculate that, right? Because that was 2.5 years ago where that whole discussion had started, and it's been making its way towards this. But in terms of how long water right transactions are taking, so your first question, we do have the ability to pull on average, right? How long applications are taking. And it's going to vary depending on the water right transaction type, right? So for example, in-stream leases are generally, Lisa, do the no or the yes when I get, if I get this, so I will stop when I get a no, you're incorrect. But they're generally taking, let's say, I don't know, under 30 days for the most part, under 45 days. Lisa, I'll get to you in a second. When we talk about transfers, I think they're taking about 1 to 2 years at this point. Same with new water right applications. So that gives you a taste. Temporary transfers, we've been, those ones were, it varied depending, and of course this varies depending on if it's groundwater or surface water. And so last year when we had pulled the report, they were taking generally, what was it? I think it was like 6 months, somewhere in there.
6 to 9.
And, or a little longer if it was particularly in groundwater cases. But still longer than I think everybody would like, right? So that one we've actually really, in part with direction from the legislature, that one's down to pretty quick, I think now. although I haven't seen the latest numbers and it's a very small sample size at the moment. But definitely those ones are meeting the, what is it, 120-day KPM. So Lisa,
Yes.
Katie, I don't know if you want to add, if we get into the protests and the contested case backlog, that one depends on the application. Some have been pending for decades, some shorter. And so that one's a much harder one to say there's an average on. So Lisa, Katie, what did I miss? That gives you all the high level.
Well, as far as in-stream leases, this last season, 67% of the applications went out in 45 days or less. Temporary transfers since July 1, 2025. And again, we're outside the normal temp transfer season, but there's been maybe 14, and we've issued all of those within our 120-day KPM, and most of those were 30 days or less. So droughts, we push hard to make sure those are issued 30 days or less. But yeah, Raquel's right on the permanent transfers. They're ranging 1 to 2 years right now, average. But we're slowly improving on the timelines there. And Raquel, I think Katie had to jump off for another meeting.
Oh, okay, that's right. Yes.
Yeah.
Lisa, does the reimbursement authority cut that down to what, 9 to 15 months or?
It's yeah, the reimbursement authority, the newest ones that have entered into the program, say in the last couple of years, those are getting issued in a year or a little less than that. So that process is speeding up because it was taking longer than that. With I guess, and it depends on it does depend on the type of transfer. So if it's involving a well location change, those generally take longer, or a character of use change, that's a little longer, but simple point of diversion changes or simple place of use changes, those don't take as much time.
And I think on the new water rights front, I don't know what the current ones are when I gave the 1 to 2 years. Justin, I don't know if you've seen any statistics lately, but I know the groundwater section made a big push to get through a lot of the groundwater reviews. And so I think now a lot of the work to be done is on the water rights front. And that was a pretty big number of water rights that they've got on their plates. So they're working their way through those, but those ones probably, I suspect many of those are taking longer than 2 years. Although once we get around with the new rule implementation, I suspect that we'll start to see those go down. I don't know, Justin, if that is consistent with what you all have been hearing and discussing.
Yep, that's how I understand it as well.
All right, thank you. Any other questions from committee members? No, okay. All right, committee, let's discuss. Let's talk about this, because first off, I'm going to ask maybe 2 or 3 questions to guide the discussion. First off, we heard this was already good dialogue with department staff, and thank you again to department staff for showing up and helping us work through this. We heard Richard's concern with public notice processes. We heard his feedback and recommendation on a potential way forward, which is broadly related to the newspaper notice change for PFOs, but isn't isn't necessarily related to other sections of the proposed rules to be changed. Stephen, definitely heard your concern as well about kind of perverse incentives related to forfeiture, which also is agreed overall, but of course is an issue outside of these proposed rule changes as well. These proposed rule changes may exacerbate that, but they're not directly dealing with forfeiture incentives or perverse incentives. So I guess my first question for the committee is, do any committee members want to raise any specific concerns from a groundwater perspective that the Groundwater Advisory Committee should consider within these proposed rules? And by specific, I'd be looking for like a line or at least a division to look at. Does anybody want to raise specific concerns about the proposed rule changes? See some head shakes. Okay, great. That's perfectly fine. Let's see. I guess the inverse of that question is now we have to discuss whether this committee wants to provide a recommendation or advice to the Water Resources Commission. And I think the inverse of that prior question is, are there any specific components of the rules that this committee is especially excited about and wants to specifically like commend or raise up or emphasize for the commission's consideration? Once again, it's okay if the answer is no. Okay, see some head shakes. And so I guess that leaves us with the third question, which is, open discussion. Does the committee want to provide feedback or advice at all to the commission? Neutral, positive, or suggesting changes or otherwise? Like, so simply, if we don't have anything, is there anything we want to specifically say and discuss providing as advice? Yes or no?
I don't
come
have
on.
anything.
All right. Great. Thank you, Stephen. Appreciate you speaking up. Let's just go through. Robin, do you have anything that you would particularly want to raise in front of the commission related to these proposed changes to the rules?
I don't think so. I do like Richard's idea of posting a notice in addition to the newspaper. But I don't know if there's room to add something like that.
Okay, let's park that. We'll come right back to it. Eric, aside from public notice for the PFO, anything specific you would like to raise from the committee or propose that the committee raise for the commission?
No.
And Richard, aside from the PFO public notice, anything else in the rules that you'd like to raise for the commission's consideration?
No, and I realize that we can't change that at this point in time anyway, so I have no complaints.
Okay. Heard, but we're still coming back to that in a second. First off, let me just close the door. I agree. I think it's okay. The GWAC should consider all groundwater related rulemakings, and we should consider our duty, our responsibility to provide feedback, advice, and recommendation to the commission. And we don't have to do it with every single rulemaking that comes in front of us. Raquel mentioned at the very top of her presentation that there's a lot going on in these rules. So a lot of these things have to do with surface water, especially Division 77 and some of the Division 380 stuff. And the stuff that does intersect with groundwater, it's important, it's valuable. From my perspective, I totally support process improvements. The committee does not need to have a formal position on it. So before I close the door entirely, though, I wanted to make sure, I'm not sure if this is a Justin and Linda question or a Lisa and Raquel question, but aside from the committee, the Groundwater Advisory Committee as a whole providing feedback, does Richard's feedback about the public notice, does that constitute public comment on the rules that you can consider?
So if you're asking the discussion in this meeting, versus having it be like put into the record, is that kind of the question?
Exactly.
We I think if we did, I don't know that in the past on GWAC that we've taken all the discussion in the meetings and then added them to the record. I think if you all request that we add it to the record as a public comment, that would just make it clear for us, right? Because to like include it in the staff report as a public comment, and we're happy to do that. And in terms of the comment itself and whether we can or can't make the change, I'm not comfortable answering that on the spot. We would need to do that analysis. So I'd say if it's something that, you know, is of interest, worst case scenario, you submit it and then we say, we don't think it's appropriate for this rulemaking, either because we don't have authority, either because we haven't really vetted it, et cetera, et cetera. But it's now on the record as something we can consider in the future. And maybe it's something that gets taken up either as a process and isn't required by rule, or so it's something that we can then say, oh, this is something that's on the record, and we'll just note that. And so, you know, there's no harm in submitting it in that sense. You just may get a response that says this is outside of the scope of this rulemaking.
Yeah, and thank you for that. We are not asking you to commit or not commit to making any changes right now, Raquel. Just trying to figure out the process for which we can officially have Richard's concerns heard. So,
Yes.
yeah,
Hey, Zach,
go ahead.
just real quick, and so I guess this is historical context, which doesn't necessarily mean it has to be the way it is going forward, and Raquel brought up an interesting possibility, but in the past, we've framed these meetings as ways for the committee to come together to discuss a potential committee recommendation, right, for which we'd ask for a motion in a second and a vote. But I want to re-emphasize that any committee member or otherwise can submit a specific public comment because the rule public comment period is open, right? And so Laura will have all the details, but that would be through either hearings, which happened last week, or I think a comment on the through the website, right? And that would put it on the record for the Secretary of State rulemaking process in a way that would be very specific. And then, as you saw during the presentation, all those comments get evaluated and common comments get bin together and the department responds to those comments. So that's another way for individual comments to be.
Yeah, and I think that's definitely the preferred option. So we make sure that the record accurately reflects the opinions, because if you submit it yourself, then you know exactly what the record will state in terms of what your opinions were on that matter.
Great, thank you for that reminder. Let's see. I agree with Robin that Richard, your comment is a good one. So I guess in lieu of having the committee actually provide a stance on this, Richard, I'll just say that I sure hope that you submit that as public comment through the website and provide that feedback to the department that way.
Yeah, just to clarify, you wouldn't submit it through the website. You would email it to me, or you can send it to me, or you can send it to the coordinator email address. I'm putting that in the chat. So either is okay, or you would mail it in, but email is probably easier. And then we would have to receive it by 5 p.m. Friday, February 6th. That's the other constraint.
Great, thank you, Laura. So here's the cheeky game plan. We're gonna adjourn the meeting a little bit early because I don't see any additional public commenters. The committee has decided against providing formal advice to the commission. And with that extra hour, Richard maybe can submit his email to Laura with his feedback about the public comments, about the draft notice for PFOs. So with that, Justin, anything else we need to take care of in the time we have today?
No, I can't think of anything. Just a reminder that our regularly scheduled meeting for GWAC will be at the end of February, Tuesday the 24th. So we'll be working to get the agenda out for that. It'll be we'll work to get the normal first meeting type stuff including, as Zach foreshadowed, selecting the chair and the co-chair for the year.
Great.
Zach, can I
Raquel,
ask sorry, I don't normally attend GWAC meetings, so just as a point of process, do you all have to take an official vote on that outcome and just make sure that people's votes are documented in the record? Sorry, you can tell I used to work at the legislature and I do a lot of commission stuff. So I just want to check on that point of process. Maybe that's not how you all do things, but I just want to make sure in the event that is best practice for you all to clarify that. And maybe I missed it.
No, you didn't miss anything, Raquel. That's a good suggestion. We in the past have voted on the advice that we provide, but we haven't voted on whether to provide advice or not provide advice. But we can do that anyway, just to make it very clear. I guess, is there a motion to not provide advice to the Water Resources Commission on these rules?
So moved.
Is there a second? Thank you. All right, any discussion needed? No? All right, let's go to a vote. Please say aye if you agree that this committee should not provide advice on these proposed rules.
Aye.
Aye.
All against?
Aye.
Wait,
Oh,
Rich,
excuse me. I misheard you, sorry.
Okay,
Only a positive.
great.
Not a
Raquel,
negative.
you didn't hear that. Don't incorporate that into your process-based mindset. Let me try one more time. All in favor of the committee not providing advice to the commission, say aye.
Aye.
Great. Any opposed to the motion? Not hearing any. All right. The Groundwater Advisory Committee shall not provide advice to the commission on the proposed changes to the rules. Raquel, what did I miss?
I think that is great. Thank you. I just, for public meetings, I get a little nitpicky on process. So it sounds, that was great. Thank you all for doing that so we can have it clearly on the record.
Of course. And Laura, I see your hand is up. Please go ahead.
Yeah, I just had a question. So we're presenting our final proposed rules to the commission March 19th. I didn't know if we needed to check back in with GWAC prior to that commission meeting. So I just wanted to ask that question.
Committee members, feel free to let me know if you have a different opinion. I don't see any need for that to happen within that time frame.
I concur with that.
Okay. Laura, you're off the hook. All right. With that, I will adjourn our special edition of the Groundwater Advisory Committee meeting. Thank you all again for spending the time this morning, especially all the time and effort that staff put into the presentation and for walking us through that discussion. Really do appreciate it. And please do not take the lack of advice from this committee as lack of enthusiasm for process improvements. I think there's a lot of great work that went into this, and we do appreciate your continued efforts. With that, thank you all. I will see you, committee members, on February 24th. Take care.
Thank you.
Thanks
Thanks,
all.
Zach. Bye.
Bye.